Hello, welcome to this video. If you are coming here for the first time, I want to say welcome to you. And if you have been watching some of our videos and you have enjoyed them, please also keep watching. Now, in this video, we want to look at how much money can someone claim for breach of human rights. You know, someone whose human rights have been breached, either he has been locked up, he has been denied his right to fair hearing, or, you know, in an unfortunate case, the right to life of someone who is close to him has been taken, or if the person is still alive, the right to life was threatened, or any of the other fundamental rights, right to own property, right to privacy of correspondence, etc., etc. You know, there are videos that we have. We've done 2 videos, part 1 and part 2, on 12 human rights for which you can claim money if they are breached. So you can just, you know, watch any of those videos, part 1, part 2, on those 12 human rights. So if any of those 12 human rights are breached, how much can you claim, and what is the basis for claiming this money? Is it just you just claim it in the air, or is there a standard? Is there a reason, you know, for claiming it? So that's what we'll be looking at in this video. All right, so don't go away, and I'll be right back in just a moment, and then we'll talk about this. 24 hours, 7 days a week. You can find your favorite program, Law and You, only on Pinnacle TV. Welcome back. So we're looking at how much money, you know, someone can actually claim when his fundamental rights are breached. So I think first off, we need to establish what is the basis actually of you know, claiming these rights. Is there some reason for it? Is there some basis, you know, for it, or is it just something that you claim because you like to claim it? So the first thing I want to say is that claiming, you know, compensation for breach of human rights is actually provided for by section 32 subsection 6 of the Constitution of the Federal Republic of Nigeria. What is the basis, what is the legal basis for claiming monetary compensation when one's fundamental rights are breached, or the fundamental rights of someone that you know has been breached? You know, so section 35 subsection 6 of the 1999 Constitution of Nigeria provides that any person who is unlawfully arrested or detained shall be entitled to compensation and public apology. So any person who is unlawfully arrested or detained shall be entitled to compensation or public apology, section 35(6) of the Constitution. Then the African Charter on Human and People's Rights, to which Nigeria is a signatory, Nigeria ratified it, also provides that when your human rights are breached, you know, I mean, they apologize, but that's nice. Apology is usually not enough. I mean, I wouldn't be happy with just an apology. Say, oh, we are sorry. You know, it may be a long 3-letter or 5-letter or 10-page letter apology, but if there's no money, you know, coming with the apology, it's not really assuaging, you know. So every person would like to receive a couple of millions along with an apology letter, okay? And as I always say, it's even possible if you bring the millions, forget the apology letter, okay? You know, but so 35(6) African Charter on Human and People's Rights allows compensation to be claimed, and these have been upheld, you know, in a couple of cases where the courts, even up to the Supreme Court, has, you know, actually decided that where there has been a breach of human rights, really and truly, apart from, you know, orders the court can make, consequentially, there must be an award of damages, award of compensation. Now, there are 3 kinds of compensation that can be claimed. So, damages, you have special damages, which relate to money that you have actually expended, some kind of refund. For example, you spent money, you know, going to hospital, you know, that ought to be refunded to you because you spend the money, you know, because of the actions of the defendant. So they ought to refund it to you. Or maybe they seized your vehicle and you were not able to make use of your vehicle for 1 or 2 months or 3 months or 4 months, as the case may be. They should be responsible for refunding you monies that you have spent in chartering vehicle, getting a taxi, so that sort of thing. So those are special damages, specific claims for refund of money that you have actually expended, and you can prove demonstrably with receipts, or such things. So that's number one. You can claim special damages. Then general damages are, damages at large, which the court sort of presumes, should be such as to restore you to the position that you were before the incident happened. If you were detained for like 2 or 3 months, something to make you feel better and compensate you. It's general damages. There is no specific standard for it. I'll talk about that. And then we have another one we call punitive or exemplary damages. That one, the court can award it in a situation where the action of the defendant has been very arbitrary, very condemnable, very oppressive, and there's a need to award the kind of damages that will deter anyone from doing any such thing in the future. So that one can be awarded as punitive, or lawyers will call it exemplary damage. So we're looking at, we have special damages, which are damages seeking to refund what you have spent. General damages, which is damages at large. Court just awards that just to, assuage the injured feelings of the claimant. And then we have exemplary or punitive damages, which is damages that are awarded mainly to sort of send a message, send a signal, teach the defendant a lesson that, this kind of conduct is not to be tolerated in our society. So those are 3 kinds of damages. We will do another video where we look extensively at these three categories of compensation, what you need to prove in order to succeed in detail in either of them. So, watch out for that video, or if you have any comment, leave a comment in the comment section of Pinnacle TV YouTube channel. Okay. All right. So that's about that. Now we've talked generally about the kind of damages that you can claim. Now in Amechi's case, Amechi versus INEC, the Supreme Court established the principle, which I just like to refer to here. Supreme Court of Nigeria, if you are watching from outside Nigeria, I mean Supreme Court of Nigeria. It stated that the court has wide powers to make consequential orders, which will remedy the situation. If there's been a breach of right, the court has wide powers to make consequential orders, to remedy the situation. Okay, so that's that. Then the Supreme Court talked about the principle of ubi jus ibi remedium. Ubi jus ibi remedium, which lawyers refer to as the legal principle that where there has been a wrong, there must be a remedy. So once somebody has established a wrong, I've been wronged in this way, the court will create a remedy. And the remedy often is to award damages to that person, to award compensation. And I always say, if you have been following some of my videos, you'd have heard me say that, one way to actually, come into some good money is when your rights are breached. Most people, when their rights are breached, they just, I don't know, I'm trying not to, okay, let me say the way they say. They say, leave it for God, that kind of thing. Say, leave it for God. God will judge, that kind of thing. So, particularly when they go to the pastor will say, God will judge, leave it for God. On one occasion, I had to tell somebody, is your pastor a lawyer? He said, no. Is your pastor a judge? He said, no. Was God, the one that beat you up? He said, no. Why would your pastor say leave it for God now? You take it to court and let the court, ask the person to give some account. So, because sometimes people really always ask, is it really possible to get monetary compensation from government when your rights are breached? They always ask that. Is it possible? Will government pay? Will they not pay? I once had a law student, who told me that their lecturer said, the problem with suing government is that it's the recovery. They will not pay, and it's difficult to collect money. You can never collect money from government. And she was telling me that was a law lecturer telling her that. law lecturer. You know, so I only told her, okay, you know what? When there's your lecturer says that, raise your hand and say, I met one lawyer at Dele who said you can collect the money from government. Whenever you are caught awards money against government, it's collectible. All right? Because courts do not make orders in vain. Every court order is an enforceable order. Everyone that the court makes is an enforceable order. You just have to understand the ways and means, you know, of how you can enforce it. You know, for those of you who study the good book says, I think in Ecclesiastes says, the labor of the foolish wearieth them because they know not how to go to the city. You know, the labor of the foolish wearieth them because they know not how to go to the city. So if you don't know how to go to the city, you will labor in vain. If you do not have the right strategies, you labor in vain. So once you have got judgment, there's a strategy to collect. There are different ways to collect your judgment debt. So we did a video on it, so you can just go and watch it. We did a video how to recover judgment debts or something like that, or guardianship proceedings. So you are free to go and watch that. But this one we are talking about how much money you can claim. Okay, now I'm just going to talk about how much money you can claim now. How do you decide? How does the court decide how much money to award? What are the parameters? I'm just going to give you like four factors that the court will consider when deciding how much to award. Okay, 4 or 5 factors, 4 or 5. So, and I'm taking them from our book. If you have been following A Guide to Successful Human Rights Litigation, Volume 1, which is a book we wrote in 2018, I think. So if you haven't got a copy of the book, you can, of course, send us, DM us, or send us a message on Pinnacle TV, and someone will get across to you. You just pay the postage. Just pay postage, then we can get you a free copy, okay? All right, and this offer is only available in 2020. 2020, so don't call me in 2021 and say, I watched your video, I want a free copy of your book, okay? So in 2020, if you watch this video and you want a free copy of the book, we can get you a free copy. Send us a message and then we'll give you that. I hope my producers will be happy with that. All right, anyway, that's fine. The publishers too, I hope they should be happy with that. So page 40 of the book, there's a list of 4 factors that the court will consider. All right. So, and by the way, you are not entitled to a copy of the book if you did not subscribe to the YouTube channel. So, we will check whether you subscribed, and then if you did not subscribe, you must subscribe before you can get a copy of the book. All right. So, the 4 factors. Number one factor the court will consider is this applicant's status. The status of the applicant. You know, all fingers are not equal. So if somebody's rights have been breached, the law allows the court to look at the status of the applicant, the status of the claimant, the status of the plaintiff. You know, I mean, who are you really in society? You know, that's a factor to consider. If you are a wealthy businessman, you know, that's a factor to consider. If you are the breadwinner of your family, you are a father, you have children, that's a factor to consider. If you are a student who is going to school, you have all these aspirations, you know, and you know, these aspirations were somehow almost dashed. That's a factor to consider. A pregnant woman detained unlawfully with her big belly, that's a factor to consider. A pastor of a church, a holy man, a clergy, a cleric, a man who is working for God, and then all this is done to him, that's a factor to consider. So, a child, you detained a child, you did this to a child, that's a factor to consider. So, there are various factors to be considered by the court, you know, and if you are preparing a fundamental rights lawsuit and you want to claim, you know, a lot of money, it's important for you to also play on the psychology of the court. You want to, what's the right word to use now? You want to accentuate, you want to underscore the part about the status of the claimant, of the applicant, that you want the court to focus on. You know, if he's a businessman, he was just doing his job, it's a factor to consider. You want to add as much as you can, you know, showing, you know, he was just doing his work, probably driving to work, you know, that sort of thing. So if you have any questions on this, please, I can't say everything on air, so you know, you can always send us a message, and you know, we can always get back to you. But now when I say send a message, I don't mean send a message about your specific individual asking for advice or all of that. We're not allowed to do videos and then we're taking advice from, you know, cases from people based on the videos that we do. No, it's not allowed for lawyers in Nigeria. What you can do, you know, if you have a specific question, of course someone can get across to you and answer, you know, your question. So number one, the applicant status. Okay, in this book, the applicant is a businessman, a law-abiding citizen, breadwinner of his family. At the time of the shooting, he was going about his lawful business of traveling on a road. Simple. That's number one, applicant status. Number two, the consistency with which such infringement occurs in recent time. This is something the court will also consider. The consistency with which infringements of this nature occurs in recent time. You know, something that it's not an isolated incident, something security agents or the defendants are fond of doing to people. You know, like these days, SARS, the Special Anti-Robbery Squad, you know, is very, very notorious for stopping people, shooting people, you know, locking people up, even taking them to ATMs or using POS to, you know, take, you know, money from them. You know, this has become very prevalent in our society. So the court will always take this into consideration as a factor in deciding how much money to award. The court will take it into consideration. So, you know, for you who is preparing a fundamental right lawsuit, or you whose fundamental rights have been breached and you are claiming monetary compensation, you want to, in a way, provide evidence to the court to show the prevalence of this sort of attitude or behavior or conduct or action on the part of the respondent, so that the court will be well-minded to, you know, award you enough, you know, compensation. You know, since it's their stock in trade, you know, of the defendant to do this sort of thing, the court will also be minded to also, you know, assist you. Now, one point you need to note here, and it's very important: don't speculate. Don't expect the court to act on your speculation. Don't just say, my lord, this kind of thing, you know, is happening, it's very rampant in recent time. No. You need to provide evidence of it. You need to depose in affidavit, you know, specific incidents. You can Google it up. If you Google SARS in Nigeria, complaints against SARS, there's even, I think there's a website run by somebody about complaints against SARS where they sort of document all of this. Or if it's breaches by the SSS, State Security Service, or by the Civil Defense Force, or whichever, you can get, you know, information, maybe newspaper cuttings, newspaper publications, internet printouts, things to substantiate the fact that this sort of conduct is very rampant in recent times. Okay, so that's number two. Number one was the court will look at the status of the applicant. That's number one. Number two, the court will look at the consistency with which this sort of infringement occurs in recent time. Number three factor the court will look at in deciding how much to award: the conduct of the respondents during the pendency of the suit. So the conduct of the respondents is a factor. I mean, if someone's been locked up unlawfully, illegally, unconstitutionally, and the person has gone to court, there's no harm in the respondents actually showing some remorse. You know, admitting to an extent that, you know, okay, we are wrong, maybe it was done by a junior officer, there was no, you know, it was not brought to the knowledge of the senior officers, or something like that. You know, I mean, we live in a humane society where, you know, the courts expect, you know, officers to act humanely. Like we say, the respondent. We had in a previous video, we talked about how the Supreme Court actually denigrated, condemned the attitude of government officials. You know, I think that was in the case of CSS bookshops versus registered trustees of Muslim community in Rivers State, when we looked at how to nullify a certificate of occupancy. So the courts have actually recognized that in most Nigerian government officials don't really give a damn about, how they treat people. So if there is a claim of fundamental right, the court will also take cognizance of the attitude of the defendant. In this case, at page 40 of the book, the statement was that the respondents have not shown any sign of remorse and regret. In fact, the respondents' conduct has been highly reprehensible. They have failed to sanction, to query, or discipline the officer. They have also abandoned the applicant to cater for his medical bills. So, these are factors that the court will take into consideration. Did you try to assist the applicant with his bills? Did you visit him in hospital? When the senior officer became aware that somebody was being detained in his station, did he take action immediately to, get him released? Did he call the investigating police officer and say, look, release the vehicle? What steps did they take? And since the case was filed in court, did they still just keep the vehicle in their custody, waiting until the court will pronounce on it? Or did they, remedy to what's the word is called in law now, to mitigate the loss of the applicant? Did they take any such steps? So all of those things the court will take into account. Or were they just stubborn and obstinate, trying to pull the applicant apart, fighting, from all the cylinders, fighting the case? Or is there a part that they showed some humanity, they considered that part, they apologized for that part, and tried to see if they could reach a reasonable settlement with the applicant? Those are factors that the court will take into consideration. All right. So okay, then a fourth point, we've looked at the applicant status, the consistency with which such infringement occurs, the conduct of the respondent during the pendency of the suit. Then fourth point, economic and social conditions prevalent in the country. That's a factor too. The value of the naira, for example, is falling every day. The inflationary trend is high. So it will be therefore necessary for the court to award sufficient amount of money to the applicant to demonstrate reprehension for the conduct of the respondent or their servant. So that sort of thing. So the court will look at the economic and social conditions that are prevalent in the country. The value of the naira and all that. So all to ensure that at the end of the day, the conduct of the respondent is shown as having been very, very reprehensible. So those are four factors you need to pay close attention to. Now, all you need to do really is to understand at this point that there is no set parameter for how much the court can award. Under the old torts law, well, this is sort of a digression, but under the old torts law, there was some parameter government had put into a law. If an arm was cut off, there's an amount for it. If it's the right arm, there's an amount for it. If it's the left arm, there's an amount. If it's one finger, there's an amount. If it's two fingers, there's an amount. If it's the whole entire 10 fingers that were cut off, but not the whole arm, there's an amount. If it's the right leg, left leg, right eye, I think all of that was put in. But that's all that if you are suing under the torts law, for lawyers will know what I mean. Now, but if you are suing for breach of fundamental right, there is no such scale, if I might call it like that. There's no such tariff, for if you are detained for 10 days, this is how much the court should award. If you are detained for 20 days and flogged, this is how much the court should award. If you are detained for 3 days but you were not flogged, this is how much the court should award. If you were fed, this is how much there's nothing like that. So all of it is dependent on the judge's perception of the events and his application of the four factors that we have analyzed. So I always recommend to people, and I would recommend if you are watching this video, to bear in mind those factors and claim as much money as you can, because the courts, for breach of right to life, the courts have awarded up to 300, 500 million, 300 million, 500 million, okay, for breach of the right to life, depending on the judge. For detention, there's also a case where breach of right to life, the court awarded 10 million naira. So that's what I said. There's no set parameter for it. You just have to show as much evidence as you can. So there's been 10 million award. There's been there's a 150 million, I think 150 million award. That was in case of I think it's Yusufu versus Attorney General of Borno State or some one case like that. That's the case where the founder of the Boko Haram sect, you know, Mr. Yusuf was arrested by. There was some disturbance when the Boko Haram Maiduguri started originally. There was some disturbance. So the army went there. They arrested the man, Mr. Yusuf. They arrested his father-in-law. And then they took them and gave them to the police. Gave them to the police. So the police executed them in cold blood. The police just killed them off. So by the time the members of their sect came, you know, to pay a visit to their leaders, they discovered that they had been killed unlawfully by the police. So, you know, they became very upset. The son of the brother-in-law to the Muhammad Yusuf, who founded the Boko Haram sect, now took the matter to court. His brother-in-law. So he sued for the killing of his father and of his brother-in-law. And the court awarded damages of about 100 or 150 million, which at this time the sect had become very restive. They were very upset, very angry. You know, they were now becoming very unruly. So in order to assuage them, the government quickly paid that money. You know, but again, you know, like, you know, they say the rest is history. You know, damage had been done. The more revolutionary elements in the Boko Haram sect now, you know, became very violent. You know, their voice, you know, had ascendancy, and then, you know, they went out from where they were living before that was clearly identifiable. They now took arms and they are fighting everywhere. So that's why we always tell the police, you know, don't breach people's human rights without court order. Don't just kill people without court order. Don't do it, because it brings more problem. You think you are solving a problem. You call somebody, say it's an armed robber, say just execute him, kill him off. You think, yeah, well, by killing him off, you are doing society a favor. You are doing more harm than good. More harm than good. Let it be that the court sentencing the person to death. Let the person be executed in accordance with. Don't take laws into your hand and say, this man has been a very bad man. He's a notorious armed robber. Just kill him off, execute him. Don't do that. So anyway, that was just an aside. In Muhammad Yusuf's case, the court awarded between 100 and 150 million naira. Now there is another case. If you are, you know, if you are a lawyer, you want to look at Precious Omana Hui, Omana Hui, something like versus IGP, where the Court of Appeal x-rayed, you know, several decisions from High Court. They looked at the Supreme Court case in AG Bello versus AG of Oyo State, where damages was awarded for the killing of that man. They looked at the case of Adiza Oje, where Adiza Oje versus Nigerian Chief of Army Staff, where the Federal High Court Lagos awarded 300 million naira, 300 and plus million naira for the killing of the husband of Adiza Oje. And they looked at several other cases, you know. So, as I said, there is no clear-cut parameter for it. It depends on the perception of the judge and all those factors, the conduct of these people, how reprehensible it is, and how much the court wants to send a message. But recommendation is, and this is my humble recommendation, you need to claim as much money as you can demonstrate you are entitled to, so that you give the court enough room, you know, actually to consider how much to give you. So the more zeros you add, the better. The more hundreds or millions of naira you can claim, the better. So you are able to give the court, you know, enough parameter to award you. But of course, the more grievous the injury, the more money you should ask for. If someone has died, the more money you should ask for. If someone has been maimed, the more money you should ask for. Someone has incurred hospital bills, the more money you should ask for. Someone has been detained unlawfully for an extended period of time, the more money you should ask for. the actions of the respondents has been quite condemnable, the more money you should ask for. All of that should play into your mind in deciding how much money to ask for breach of fundamental rights. I think it's a convenient place for us to stop this video. If you have not subscribed, but if you like the video, do subscribe, click the notification bell, and then so that you can get regular updates of all videos that we load, and then you can give us a thumbs up and then share the video. See you in the next video. Bye bye. 24 hours, 7 days a week. You can find your favorite program, Law and You, only on Pinnacle TV.